The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to the second case on our calendar this morning. This one is a remote argument. It is case number 21-366, Cape Homeowners Association et al. Versus Southern Destiny LLC. We've confirmed that the parties are ready to proceed, so we'll hear from the appellant.
Counsel for the appellant, I want to first thank the court for indulging a conflict that I had that prohibited me from appearing in person, and with the gracious consent of counsel for the defendant, the court granted our request for this argument to be held via WebEx, and I just thank you for that. In this de novo review here from the grant of summary judgment in favor of the defendant and against the plaintiff and the denial of the plaintiff's motion for summary judgment, the material facts, the attendant circumstances from 1986 surrounding the history of the development of the Cape, its private streets, the Cape Golf Course are not in dispute. Pursuant to a common scheme of development, the Cape and its sensitive infrastructure, including its system of drainage, critical components of which are located on the golf course that the defendant wishes to develop, in the design and configuration of the private streets of the Cape, what property would be reserved for future development. The original developer of the Cape never intended that the Cape Golf Course be developed, and therefore never intended that the private streets maintained by homeowners in the Cape be used for that purpose, and there is simply no evidence to the contrary. The Cape developer has testified that pursuant to a common scheme of development, it was its intent to dedicate the golf course for the use and benefit of purchasers who bought property by reference to recorded plats that showed the Cape Golf Course. There is no dispute that the existence of the Cape Golf Course was an inducement for purchasers to buy property within the Cape. The original developer intended that the private streets within the Cape be owned and maintained by the Cape Homeowners Association, and that pursuant to the corresponding declarations of covenants, that each purchaser of property within the Cape would become a member of the Homeowners Association, funded by monies that hundreds of lot owners within the Cape would pay, and for more than 35 years have paid. Lot owners that, by reason of the numerous deeds conveying property pursuant to recorded plats and the declarations for the Cape, therefore acquired an interest in the nature of an easement appurtenant in and to the private streets within the Cape, and we contend the Cape Golf Course. The proximity, the location of the Cape Golf Course was an inducement to get people to buy property in the Cape. The recorded plats not only show the precise location of the Cape Golf Course in relationship to the property sold by the Cape developers and its successors, but it also shows any areas reserved for future development, which did not include the Cape Golf Course. The Cape developer has confirmed that if the Cape Golf Course had been intended for future development, it would have been specifically labeled as such. In September of 1986, after hundreds of lots had been sold and conveyed by reference to this common scheme of development, by reference to these recorded plats, the original Cape developer conveyed what it labeled Track 1, the Cape Golf Course, through Track 5, the Cape Golf Course, to Midway Partners, who then immediately conveyed it to one of the defendant's predecessors Untitled. However, the conveyance of the Cape Golf Course to Midway Partners by the Cape developer contained no express easements over the private streets and roads of the Cape. when at the same time, the Cape developers separated title to the remaining unsold portions of the Cape and other areas that had been expressly labeled and designated as reserved for future development. It accepted from that conveyance all of the property conveyed in sections of the Cape shown on the recorded plats, which obviously included all of the private streets located thereon. That conveyance likewise contains no express grant of an easement over the private streets of the Cape. Immediately, what was then also labeled as tracks 1 through 5 of the Cape Golf Course was conveyed to Thomas Wright with a precise meets and bounds description of each one of those tracks. There's never been any dispute about the very precise location of the Cape Golf Course. The conveyance of tracks 1 through 5 of the Cape Golf Course was conveyed together with various easements that are set forth over a series of 3 pages, not just one sentence. Yet, that is what the defendant chooses to focus its claim of an express easement upon. A word or two only from a portion of a single sentence within the entire deed, and principally focus upon the word vehicular, ignoring the words that come before or after, ignoring the limitations contained within any express easement within the sentence that they claim being limited to property described on the missing Exhibit I. The suggestion that the missing Exhibit I was never raised in the trial court is obviously belied by the record. After the trial court gave its preliminary ruling, pursuant to Rule 52 and 59, we pointed out to the trial court that it could not, much less the defendant, rely upon this sentence as a basis for its holding that the defendant held an express easement because there was no Exhibit I. So those were the attendant circumstances in 1986 and for the next 30 years. This case is therefore not about whether at any time the owners of the golf course and those members of the public, those people within the Cape playing golf there, ever had an express or implied right to use the private streets of the Cape for the operation of the golf course. This appeal focuses initially upon whether the defendant has established that in 1986, the owners of the golf course acquired an express easement over all the private streets of the Cape for any purpose, including but not limited to the development of the golf course. It is indeed the defendant's contention that it acquired in 1986 an express easement over all of the private streets of the Cape to conduct any lawful operation on the property that is otherwise known as the Cape Golf Course. And therefore, they contend that at that time, it correspondingly acquired the right to use the private streets of the Cape for any lawful purpose. So we contend that without it providing any evidence to support its contentions, it is the defendant wishes to rewrite the attendant circumstances that existed in 1986 or that was otherwise already of record in 1986 without providing any evidence whatsoever to fit its narrative, because it's the defendant that contends, and I think it's important for this court to understand, that the 1986 deed upon which it relies gave it the right as the owner of the golf course to immediately close the golf course in 1986 and to therefore begin using immediately the private streets and roads for any purpose other than the operation of the golf course, including the development of the golf course.
I want to jump in and ask a question. So, and can you hear me okay?
Yes, ma'am, I can. Thank you.
All right. So I understand your argument that those driving over the streets can drive over them as long as the property is a golf course, correct?
Yes, ma'am.
So as soon as the golf course ceased being a golf course, then nobody who was supposed to drive over those streets for the golf course can use those streets, correct?
Not pursuing any express easement. No,
Okay.
ma'am.
All right, and all of the alternate theories have been dismissed, correct?
Yes, ma'am.
All
All of
right.
them. Go ahead.
Okay, so my next question is, are you contending that the owners of the property must in perpetuity continue the use of this property as a golf course?
No, ma'am.
Okay.
I'm they
All right,
cannot.
so the next question is, if it's not as a golf course, but let's just say they don't develop it, let's just say they don't have the money to develop it. They don't have the money, I'm sorry, to keep it as a golf course, correct? But they're not allowed to develop it. Would they be allowed to drive over the streets to say mow it, or would it just be left as just wild grass forevermore?
It would be left as many open spaces are, Your Honor, in New Hanover County. It would be left as an open space subject to the laws, both common and statutory, as to what maintenance that the owner of that property must undertake. Next, if in fact we, the plaintiffs, have the right in the nature of an easement appurtenant, then we contend, and that's not something for the court to decide now. We have a right to enter upon the property to maintain it. And we may have a right to then charge any cost that we incur in the maintenance of this common property, because we're only acquiring an easement across it. We may be able to charge those costs back to the owner of the servient estate. But that's not the issue now. It's a two-headed monster, if you will. First, did the parties contemplate that in 1986, the owner of the golf course could simply close it down and immediately begin using the golf course for any other purpose and therefore use the private streets of the Cape for that purpose? If the answer is under that 1986 deed, the answer is no. And all of the other bases upon which any claim of an easement so that they can develop the golf course has been dismissed, then it focuses right back, Your Honor, on what is the nature of easements and someone's desire to use my property. It becomes a matter of agreement. It will be incumbent upon the owner of the golf course, if
So
it wishes to.
under your argument, then the owners of the property would not be able to access the property over your streets unless they continued as a golf course, correct?
Oh, I believe that they could absolutely continue to access it for purposes of maintaining it. Absolutely, positively, for their reasonable use and enjoyment, not inconsistent with the rights of the Cape owners. No, sure. I think that is what was contemplated in the 1986 deed. You simply cannot put it to a use inconsistent with the common plan and scheme of development that were the attendant circumstances that existed in 1986. Because if we're going to change both the use and scope, even the case that the defendant cites, the Charlotte case, for the notion that that's all okay, makes it clear that's not okay. That you can't place it to a use. You can't exceed the scope that the document upon which you rely contemplates existed at that time. Because, of course, the purpose of this court is to construe the intentions of the parties from the 1986 deed. The defendant contends that you don't get to hear any of the extrinsic evidence / attendant circumstances. And that may be true if the entirety of the deed upon which they rely was abundantly clear. But as the cases make clear, when it's less than clear, as here, no Exhibit I, we have two separately described by metes and bounds 60-foot easements granted to the owner of the golf course, which the defendant, of course, made no attempt to put those on the ground and to show the court where those are. We have the 35-year use by the owner of the golf course and those playing golf at the golf course as in terms of the use of the private streets in that 35-year period, meaning there's never been any contention by the owner of the golf course that we can close it down and we can use your streets for purposes of anything we want to do. There's never been that contention. And so you got to look at the use that the owner of the easement, alleged express easement, made of those 30 years. And they never used it for any other purpose other than as access to a golf course. If we're now going to change the use from that as a golf course pursuant to a common scheme of development, and we're now going to build hundreds of homes on the golf course that contains sensitive drainage infrastructure that serves the entire development, if we're going to abandon what has been undisputed by the Cape developer to be the common scheme of development, then at the very least, there exist issues of fact as to whether or not the parties to that 1986 deed ever contemplated that that would be the case. Said another way, that's why the trial court should have granted our motion for summary judgment, because the defendant presented nothing as to the attendant circumstances that would support a construction of that 1986 deed, that they could close the golf course down immediately and begin using the private streets of the Cape for any purpose that was otherwise lawful. There's nothing that supports that, and we don't think that document read Nocetur a socius. I hope I did not butcher that from a Latin perspective, where we've got to look not just at a word or two, we got to look at certainly the entire sentence that includes the missing exhibit I that starts with a capital letter and ends with a period. We've got to look at the entire sentence, and given these circumstances, we've got to look at the entire document. And there's nothing in the entirety of the document or the entirety of the sentence that would support the narrative that the defendant contends that exists. So we think that as a matter of law, the defendant who bears the burden of proving the express easement that it claims, that as a matter of law, it failed to do that. It did not put the easement on the ground that it contends exists to develop that portion of the course that it now seeks to develop. They didn't try to do that. They simply contend we have an easement over all the streets. If Your Honor, if the court does not adopt our position as we believe it should out of law, they didn't prove that, then certainly there are genuine issues of fact as to whether or not the attendant circumstances in 1986 that were unrebutted lend themselves to that kind of construction. The cases that they cite for the idea that, oh, changing the use doesn't matter, in all due respect, they don't support the position that they take as we set forth in our reply brief. Or at the very least, they raise issues of fact with respect to their contention, which
are you changing the use of the roads? The use of the roads is for driving your car, correct? If you change the use of the end goal, which is either to get on the golf course property or the developed property, is that changing the use of the roads? You're still just driving on them.
Well, you're bringing heavy equipment across them to develop. You're bringing trucks, lumber trucks in and out. It's a use that is different. And you've got to next look at the entirety of the document. The defendant contends you just can ignore the term golf course that's located throughout the entirety of the document. We don't think as a matter of law you can do that. You got to look at the attendant circumstances, which were a matter of public record, including a precise meets and bounds description of track 1 Cape golf course through track 5. Those were all of record, all of the plats at the time that the express easement that it contends exists in a portion of that single sentence was created. Your Honor, in all due respect, no Satura Associates. You cannot take that single term vehicular in that portion of that sentence alone and read it by itself as granting an express easement over all. And that's the other point. All, everyone, not just the streets that we as the owner of the golf course and members of the public use to get back and forth to the golf course, not just those, all. So we can say from the 1986 deed, that's clearly what the parties intended. I think not, which I think blends nicely, given especially the unrebutted testimony from the Cape developer about the common scheme of development, its intent to dedicate the Cape golf course. We contend that just like the streets, as a matter of law, the owners of the Cape, the plaintiffs, have acquired an interest in the nature of an easement appurtenant. Not only over the private streets, but over the golf course that can't be terminated without their consent. Easement by plat is well recognized. We have distinguished, and I want to make it clear, the cases upon which the defendant relies. This is not the Crooked Creek case. Crooked Creek case, none of the recorded plats depicted a golf course. Lots were not sold by reference to any map that depicted a golf course. The defendants never referenced, deeds never referenced any map that referenced the golf course. This isn't the Harry versus Bassett case. Unlabeled remnant parcels. No representations were ever made about those unnamed remnant parcels. As this course stated, those properties were, quote, not designated for any specific purpose, weren't labeled in any way. This isn't the Red Fox case, where the defendants, Judge Collins, contended that the property had to be used as a golf course. No. There was nothing of record in the Red Fox case to show the precise boundaries at the time the plaintiffs claimed an interest as to what the Red Fox Country Club was. Here there is. There's a precise meets and bounds description of tracks 1 through 5 of the Cape golf course. This court hung.
Does it matter that the golf course was never, that there's no depiction of the entire golf course in its entirety, that it is cut up into 5 different plats?
No, ma'am, because again, the entirety of the Cape golf course, unrebutted, was pursuant to a common scheme of development. If you look at the 2006 plat, which was the plat by reference that the defendant acquired title, it lays out in graphic detail not only the meets and bounds, but all of the plats surrounding all of the holes of the golf course that were recorded. It gives the precise books and page. So no, because if there was a dispute about what constitutes the Cape golf course, maybe, but here there's no dispute. By the time that the defendant acquired title and acquired the express easement that it claims, tracks 1 through 5 labeled as the Cape golf course was already of record. So we don't have, like the Red Fox case, we don't have any uncertainty as to what the precise boundaries are of the Cape golf course. While this isn't the Spring Farm case, where you had ambiguities in a declaration. This is not a restrictive covenant case. I know the defendant refers to restrictive covenant cases, but it's not. We think this is more like the Shear case than any case. And in fact, in terms of the unrebutted facts, it's the most unique case in the cases dealing with dedication by plat. Why? You have unrebutted evidence from the developer as to what its intentions were. Then we have, pursuant to that common scheme of development was undertaken, and in 2006, the defendant took title to a golf course where the entirety of the Cape development had been developed around it. Those are the circumstances. That makes this case unique. The defendant wants to contend that somehow because the developer was the defendant in Shear, that matters. we don't think that matters. Why? Because the plaintiff's interests were acquired by reference to deeds that referenced recorded plats that showed not only the private streets, but showed the Cape Golf Course. And then in 1986, we know the entirety of the Cape Golf Course. It is described by meets and bounds. So
can you just explain very quickly this portion of the deed that is relied upon, this key language? It hasn't appeared in all of the deeds going back and going forward, correct? It appears and then it seems to disappear.
yes, ma'am. It appears in the 1986 deed from Midway to Right. That's where it first appears. But it does not appear prior to that, and it does not appear after that in any of the conveyances of the golf course. Because again, the defendant acquired title pursuant to a recorded plat that labeled tracks 1 through 5 of the Cape Golf Course and labeled the plat the Cape Golf Course. I'd like to reserve the remaining time for rebuttal.
All right, thank you, counsel. We'll hear from the appellee.
To please the court, I'm Raul Taylor with Warden Smith and represent the defendant Southern Destiny in this case. So I'd like to first point out a few things that the plaintiff's argument is ever evolving. And for the first time in its brief to this court, it argues that the subdivision streets were accepted in the deed to Midway Partners from the original developer, that Midway didn't own the streets when they were conveyed, when the golf course property was conveyed to Maddie, and that the failure of the deed from Maddie to Right to have an Exhibit I is fatal to the grant of the easement. None of this was argued at the summary judgment hearing on November 5, 2020. Some reference was made to this Exhibit I argument in the motion, the hearing on the motion to amend the findings and conclusions. But the whole argument all along has been, yes, Southern Destiny has an easement. And I think that's what Mr. Shipman just said in response to your question, Judge Collins, about whether the Southern Destiny had the right to go over the streets to maintain the property, even though the golf course had ceased operation. But it's just, it jumps around. And in their reply to the counterclaim, which is in the record at page 175, on the second page of the reply, the third defense says, defendant, that's Southern Destiny, had an easement over the subdivision roads, and then goes on to say, but it was terminated when it ceased using the property as a golf course. In paragraph 8 of our counterclaim, we allege that Midway owned the golf course and the subdivision roads. They admitted that. In paragraph 14 of the counterclaim and the reply, the plaintiffs admitted that Southern Destiny was conveyed this roads easement that shows up in these deeds. In paragraph 26 of the reply, it says Southern Destiny and its predecessors have used the subdivision roads for access for over 20 years. In paragraph 29,
Isn't all of this referring to the use of the roads for access to the golf course? And isn't that the crux of this argument, is that if it's not a golf course, they don't have an easement over the roads for any purpose under the sun, including accessing a brand new development of a bunch of homes?
that is their argument. And we would say, just like Judge Harrell said, that the scope of the easement is clear and unambiguous. That the easement says that, and let's bring that up. I'd like to share this screen with you if I could, please. So this is the deed from Midway Partners to the Maddies. Can you all see that?
Yes, we can.
Okay, and so this was in 1986. The Maddies conveyed the property to Thomas Wright, who owned the property for 20 years. And then Thomas Wright sold this property, the golf course property, if you will, to our client, Southern Destiny. So that's the deed, and it says, you know, the description's on Exhibit A, and if you flip through the description to the part where the easement starts, which is record page 113, it says the tracks 1 through 5 are conveyed together with the following easements, which shall be appurtenant to and run with the land. There's no question it's an appurtenant easement. And at the bottom of the page, that's the easement. It says, together with an easement for vehicular, golf course, and pedestrian use by the grantee's successors and assigns, and their guests and members of the public playing golf across all the streets and roads of the Cape subdivision. Now, why, if it was limited to golf course use, and every golf course has an entry point where you go to the pro shop to go play golf, why would the conveyance have been for all the streets and roads in the subdivision if it was just going to limit it to golf course use? Where's the for so long as?
Okay, my question, so this language appears in the deed from Midway to Maddies or from Maddies to Wright?
And from Maddie to Wright, and it's an appurtenant easement, so black
From
letter law.
Maddies to Wright?
Black letter law is that even though it does not appear in the deed from Wright to Southern Destiny, because it's an appurtenant easement, it goes with the land when the land is conveyed.
All right, and did it appear in whatever deed went to Maddies?
This is the deed to Maddie.
Okay, and then what about Midway to Maddies?
This is Midway to Maddie, and then
Okay.
Maddie to Wright, yes, the very same language appears, this exact same language.
Okay, I guess I'm trying to get to what happened, what language was before this? How did this all of a sudden just pop up is my question.
Okay, so Midway was conveyed all the property.
Okay.
All the subdivision property that had not already been conveyed. And all of the golf course property, so, which included the roads. And they've admitted that Midway owned the subdivision property, the roads, and the golf course property when it conveyed the golf course property to the Maddies and conveyed this roads easement. Now, obviously,
Your argument is that they have the authority then to grant this easement because they had control of it.
because they own the roads.
Okay.
Yes, that is absolutely true. So this whole argument where they've admitted everything in their reply that this thing wasn't conveyed properly is just incorrect. And they admitted in their reply that this roads easement right here, this is a defined term in our counterclaim. They admitted that this roads easement right here was conveyed to Southern Destiny. So that's not an issue in the case. And you'll also see that this description of the easement says that including but not limited to the recorded maps to which reference is made in the foregoing descriptions of tracks 1 through 5. And if you go back into the descriptions, I've highlighted various places where map books and pages show. Well, I counted, there were 16 references to maps, different maps in this description in this deed. 13 of those are attached to plaintiff's complaint. So the very same roads that the plaintiffs are using to get to and from their properties are the same roads that the golf course is entitled to use. And as I was saying earlier, the easement includes all of the roads. So if there wasn't a contemplated future purpose of the golf course other than this, why would it say all the roads? Why not just give them access to certain access points to the golf course? And on top of that, the plaintiff is conflating the use of the easement with use of the property, as I think you were trying to ask. It's an access easement. We can use that access easement for any lawful purpose that we put our property to, because it's not limited to anything. It doesn't say you are limited to using the roads as long as you use it as a golf course. It doesn't say that. It doesn't, there's no limitation in there. And so it's a very broad easement. And I would suggest to you that I would think any real estate practitioner would say this is a pretty well worded, broad easement, and that clearly provides access. As Judge Harrell found, the dominant and servient estates are precisely described. The nature of the easement, the scope of the easement is precisely described, and and the roads are shown on maps. They're referred to on the maps, and they have meets and bounds description, and they've been in use for 40 years. Judge Harrell determined that the lack of continued use as a golf course does not nullify the grant of the easement. We cited, and so did the plaintiffs, the Shingleton case. And it's on page 24 of our brief. And that was a North Carolina Supreme Court case from 1963, and at 260 NC at 457 and in 133 Southeast 2nd at 187, the Supreme Court said, an unlimited conveyance of an easement is in law a grant of unlimited reasonable use. Such grant is not restricted to use merely for the purposes of the dominant estate as are reasonably required at the date of the grant.
So then now we had a question of fact as to whether changing a golf course to a development is a reasonable use for the people driving over?
Well, it's a vehicular access easement. That's what, just like you asked Mr. Shipman, well, aren't they going to drive cars over it? Yes, they are. And they're going to drive trucks over it to build the houses, probably, just like they did and are probably doing now whenever they build a house in the Cape subdivision or redo one. But this Shingleton case says that the right may be exercised by the owners of the dominant estate for any use to which the latter estate may be subsequently devoted. So the Supreme Court has said that you can change the use of the land, you just can't change the use of the easement. And that's like the Swain case that he's talking about, which we get into overburdenment. But the Swain case that's cited, in Swain, an access easement was provided, and the easement holder wanted to put utilities down the access easement, and the court said, no, you can't do that. You were granted an access easement, not a utilities easement. And in the City of Charlotte case versus BMJ that we've cited, there's a real good discussion about overburdenment and what that means, and that there are only two situations in North Carolina where there's overburdenment. If Southern Destiny wanted to grant someone else an easement over the subdivision roads, some adjoining property owner, it can't do that. That's an overburdenment. You can't do that. And the other is if the easement language itself says restricts the easement to a particular use, then you can't use like I said, an access easement for the installation of utilities.
Doesn't an access easement imply access to something particular?
Yeah, and there is access. The access is to this property, which was at the time we were conveyed the property a golf course. But that doesn't mean that the use can't be changed. I mean, you think of all the easements. I mean, to different properties around through a shopping center, you have an easement to a Walmart, and if that Walmart changes to several different shops, they convert the Walmart to several different shops. Does the easement die? No, even though that's gonna maybe increase the volume, and just like this may increase the volume, but you had a golf course that was open presumably 10 hours a day in the summer, and if you have 6 foursomes an hour, that's 24 an hour times 10, that's 240 cars. You got 132 houses that are being planned here. What is there a difference is there an overburdenment? It's just, is there any
A question of fact, another reason to send it back and find out?
pardon?
isn't that a question of fact that we should send back to find out?
No, it's not, because it doesn't matter, because the City of Charlotte case says that an increase in vehicular traffic is not an overburdenment of the easement. And that in that case, the trains were going for, I think it said one, two or three times a week to 10 trains an hour. So that's not an issue of fact. And the City of Charlotte case cites another case from Massachusetts where a footpath was used for one house, and they increased it to 5 houses, put 5 houses on the property that was benefited by the easement. And the court said that's not an overburdenment, that an increase in traffic is not an overburdenment because it's an access easement.
Can I switch arguments or questions real quick? So I'm concerned about the missing Exhibit 1.
Okay, so
What's the court supposed to do with that?
all right, well, Exhibit I, but
Okay.
the terms of the easement first by referring to the specific maps is precise enough, and that's what Judge Harrell found. But if you look in the record at page, the documentary Exhibit 310 is a deed from Carolina Resorts, the original developer, to Midway. So that's the deed right before this one that I was showing you a minute ago from Midway to Maddies. That deed to Midway at document Exhibit 310 has an Exhibit I that obviously was the Exhibit I that was meant to be attached. And it's just
Did you say obviously was or wasn't?
obviously was, because it's the 600 and some acres that extends all the way from River Road to the west to Carolina Beach Road to the right, and that Exhibit I is Exhibit 312 in the documents, and you can take a look at that. But the easement is precise enough without the Exhibit I being attached. And it's not unusual, I don't think, in these situations for things to be left off with that really ultimately make no difference. For example, the articles of incorporation of the Homeowners Association leave off an Exhibit A that describes the property that they're supposed to be governing. So that's in the documentary exhibits too. So I'd like to turn now to the easement implied by plat. I think it's interesting to note that even though Judge Harrell cited the Red Fox case that Judge Collins, you authored a year ago, which involved a golf course, which had no meets and bounds description on the maps pursuant to which the plaintiffs obtained title to their property. Their lots referenced, their deeds to their lots referenced maps that showed the golf course as an adjoining property, but didn't have any kind of way to figure out what the meets and bounds description of that. Judge Harrell referenced the Red Fox case in his order. In fact, that Red Fox case was decided after we argued to Judge Harrell on November 5th and before he finished his ruling, or made his ruling, I should say. The plaintiff's brief makes no reference to the Red Fox case. We cited it in our brief, of course. The plaintiff's reply brief makes no reference to the Red Fox case. The Red Fox case is dead on point. It discusses all these other cases that deal with golf courses being converted to residential subdivisions. And it talks about the Shear case, maybe not the Shear case, but the Crooked Creek case, which is, in that case, a later map was prepared where the original developers of the subdivision and golf course conveyed the golf course to someone else or either prepared a map, but none of the lots were conveyed pursuant to that map. And you made that distinction in that case and said it doesn't matter if a later map was done showing the golf course. What matters is the maps pursuant to which the plaintiffs got their deeds in order to get this easement implied by plat. This is not the case we had in Cleveland Realty versus Hobbs, which is like the seminal implied by plat case, where the map pursuant to which the plaintiffs took their deeds actually had a note on it that said the golf links are for the use and benefit of the property owners. We don't have that here. There's nothing clear and unambiguous showing that there's any kind of restriction on the use that can be made of the golf course. And they're trying to convert this easement, which is a broad, unlimited access easement, into some sort of restriction on the use of the golf course. You don't ever get to this extrinsic evidence of what the situation of the parties were or anything like that, because no interpretation is needed of this access easement. It is clear and unambiguous, and Judge Harrell found that it was precise and clear and unambiguous. And I think any real estate practitioner in North Carolina would as well. So, and especially what the developer has to say in a deposition some 20, 30 years later is completely inadmissible. He can't tell what his intention was at this late date in the game. And he doesn't really unequivocally say that anyways. It was my intention that the golf course would never close. It was not ever my intention that the streets would be used to develop the golf course property. Of course, but he's been out of the picture since the early 80s. He was not a part of Midway Partners and was out of the Carolina resorts by then. So his opinion or his testimony as to what his intention was is just inadmissible and not applicable and contrary to the parole evidence rule. This easement implied by plat. In order to have an easement, you've got to have some right to use the golf course property. The property owners had no right to go on that property. The HOA itself even sent out a notice, and that's included in one of our affidavits, that do not trespass on the golf course property. That's what they told their property owners. There were signs that said, don't come on the property because the cart paths cross the streets of the subdivision. And there were signs where those cart paths cross on the cart path saying no trespassing, only for members and their guests. So the property owners have never had a right to use the golf course property, and that makes perfect sense. A golf course is not like a lake or a park. And that there's no evidence that they ever had any right. We provided several affidavits to that fact, and one other fact that Judge Harrell picked up on was that Thomas Wright, when he owned the golf course property, carved residential lots out of the golf course property and sold them. Their houses built on them. They used the roads in the subdivision to get to and from their property, and they pay dues to the homeowners association, even though there's no document saying that they're members of the homeowners association. So the easement implied by plat case, I think, is determined by the Red Fox case and the other cases we've cited in our brief. And unless the court has any other questions, I'll turn it back over to Mr. Shipman.
All right, thank you, counsel. Any rebuttal?
Nositor associatus. Of course, in Mr. Taylor's arguments, he omitted, Judge Collins, the Exhibit I. This is the first time that appears into the record ever that the defendant has contended that Exhibit I was not a part of this conveyance, which is what the Senate says, but that was part of another conveyance. First time we've heard it. How did all of this pop up after 1986? Judge Collins, you asked that question. We don't know, because the defendant didn't present any evidence as to what the attendant circumstances were. Midway owned the roads, sure, but subject to the rights that had already been created to the owners of property within the Cape to those private streets and roads. It's an access easement. It's not limited to anything. You cannot read the entirety of the document. and adopt that position, at least without letting a trier of fact pass upon whether or not this use was in fact a use that was contemplated. Unlimited use, citing the Shingleton case. Again, you simply cannot look at the entirety of the 1986 deed and say that there was a grant, as in Shingleton, of unlimited use. The Charlotte case. Note what the court said in the Charlotte case. It was a railroad case. It was an easement granted for railroad purposes. When the court said there, a change in use entirely or to add a different non-railroad type of use, their holding may be different. Why? Because an easement is a contract. And the purpose of the court in enforcing an easement is to enforce the intent of the parties. And there's no evidence that the defendant presented that would lead to a reasonable construction to adopt that as being the intent.
Counsel, what is,
I'm sorry, did somebody ask a
what
question?
is the, so if the language of the easement says this is a vehicular easement across all roads in the Cape subdivision, how do we get from that to the argument you're making that, well, we should read it? In other words, if isn't the best evidence of what the easement is conveyed, what access is conveyed, just the words that were chosen in the instrument?
In the entirety of the instrument, Your Honor, not just that portion. You've got to determine from the entirety of the instrument that conveyed tracks 1 through 5 of what it was labeled as the Cape Golf Course, that it was the intention of the parties to that document that the owner of the golf course could immediately close it down and begin using all of the private streets of the Cape for any purpose. And we don't think the court can do that, not as a matter of law. As a matter of fact, a jury may determine that that does not exceed the attendant circumstances that the parties contemplated in 1986, but that by itself cannot, we contend, lead to a conclusion that as a matter of law, this is clear and unambiguous, like the Shingleton case, where we're simply talking about a easement for ingress and egress. As the courts have said, as this court has said, if any greater use had been intended beyond that stated in the entirety of the document, it could and should have said so. Said another way, if using all of the streets within the Cape for any purpose was within the contemplation of the parties and that was the scope that was intended, the document clearly could have said so. The burden was on the defendant to prove the express easement that it claimed, and it hadn't done that. Or before the court can adopt the defendant's versions, there are issues of fact to have a jury determine. The intent of the Cape developers was to dedicate the streets. So, of course, pursuant to that same common scheme of development, its actions in recording these plats are in furtherance of that intent to dedicate the streets, and we contend to dedicate the golf course pursuant to that common scheme. For the court to hold otherwise would not only ignore, as the defendant says you should, ignoring the intended circumstances, but it would condone, we contend, deception. It would ignore the uses that have been made for 35 years of the streets, and we don't believe the court can do that. I thank you, Your Honors, for your attention.
All right, thank you, counsel. Thank you both for your arguments. We'll adjourn. Mr. Harris?
This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you. I always say at the end here,